The petitioner is hereby allowed to visit the minor child on 9 to 22 between 4 to 6 p.m. at City Center Mall, Mangalore, in the presence of the respondent or any other person the child is comfortable with, in the presence of Srimati so-and-so. The third session was on 22/3/22, where the child was comfortable and relaxed. In the session, both the parents were called to the therapy room and the communication with the child was continued by the therapist. As soon as the father came to the room, it was seen that the child ran to the mother and clung to her. Throughout the marriage was there was no harmony between the parties.
The child was with the father till she is 3 years old.
Yes. She was born in the USA. She is a natural citizen of USA and she holds the passport of US also.
Then the GNWC is filed in 2020.
Yes.
Every day.
That is the. Then sometimes she used to bring the child to the court. Then I have seen, but not interacted with the child.
Mother is not permitting until she is going there and she's trying to hold her.
Child is coming back to the mother. No.
Why a girl of 5 years, her maturity, her this thing is not as what is supposed to be, then what the mother is doing. It is not normal. A 5 years old girl won't behave like that. If she is behaving, then the mother is not taking care of her overall well-being. That has to be the inference.
The child is concerned.
Yes.
Appearing for the wife as husband, my lord. There are two proceedings. One under the Guardian and Wardship Act, and another is for divorce. Husband has filed the petition seeking for the custody of the child, who is aged about 7 years now.
What did the court do on interim custody?
Court, my lord, has granted a limited visitation right between my lord on Saturdays in the court premises for fixed hours. Sought for interim custody of the child during the summer vacation and winter vacation.
What we'll do is, first we'll look at the order as far as the interim custody is concerned.
Yes.
Please come.
That is the. Initially, my lord, I had filed IA number 5.
GNWC is filed when?
GNWC is filed by the husband.
Here.
Yes.
It's of the year 2021.
Yes.
IA is filed immediately.
Yes, ma'am. IA number 5 was filed, seeking for interim custody of the child during the vacation time, and also for visitation right during Saturdays and Sundays. My lord, that was granted by the court as per order on IA number 5, dated 7/2, page, my lord.
7/2/2022. Where is the order?
Yes, ma'am. Page, my lord. 140. Annexure E. My lord, the operative portion of the order is at 153. IA number 5 filed by the petitioner under section 12 of the Guardians and Wards Act is hereby partly allowed. The petitioner is hereby allowed to visit the minor child on 9 to 22 between 4 to 6 p.m. at City Center Mall, Mangalore, in the presence of the respondent or any other person the child is comfortable with, in the presence of Srimati so-and-so, the learned counsel for the respondent. The petitioner is hereby permitted to visit the child for 2 hours between 5 to 7 p.m. on all Saturdays and Sundays, and he shall be given the custody of the child during that period. The child shall be given to the interim custody of the petitioner for a period of 1 week during the summer vacation in the month of April, and 1 week in May, and also for 3 days during Dasara vacation and 3 days during Christmas vacation. Advocate so-and-so and the panel of advocate is hereby appointed as advocate commissioner to accompany the child during the time when she is taken to councelling. The clause number 2 and 3 of this order, that is visitation right and interim custody of the child as sought for in IA number 5, are kept in abeyance till the report from the pediatric psychologist is placed before the court. Later on, the pediatric psychiatrist has given a report. That is at page 155. There the mother did not cooperate. Your lordship may kindly see the report, my lord, at page 155. The second paragraph, second session on 12/3/22, again the child Arabanti was carried to the therapy room by the mother. The child was more at ease. She greeted the therapist and started to converse in English and asked for the color pencils to draw. This day she also accompanied the therapist to the fish aquarium nearby. In the same building. When returning back, she saw her mother and clung to her, and regressed behavior was observed, where she started to cry and demanded that she wants to go home. Mother was very upset, stating that the child is being spoken to by others, and that is why she is uncomfortable. Third session was on 22/3/22, where the child was comfortable and relaxed. In the session, both the parents were called to the therapy room and the communication with the child was continued by the therapist. As soon as the father came to the room, it was seen that the child ran to the mother and clung to her. The therapist called the child to her side and asked her to continue drawing. The child became relaxed and was at ease. Father was trying to communicate to the child by encouraging her to draw, which made the mother very uncomfortable and disturbed. The object objective of the session was at her place prior to the child in her drawing. When it was over, again the mother carried the child and went off. Yes. My lord, thereafter, since this report was not obtained, I filed a memo. On the memo, court passed an order which was to be in force, page, my lord, 180. On the memo, the court permitted me to exercise my visitation right on every Saturday, 4 p.m. to 5 p.m. from 7/5/22 for the time being for the period of 3 months. This order was passed, which was to remain in force till 3 months. IA number 5, my lord, there was no variation.
For 3 months?
Yes, that is,
3 months.
yes.
This is dated?
This is dated 24, man. 24/22, man.
24/20/22.
IA number 5 order was in force.
Yes.
The
Then
court
why-
passed an interim order.
Then what made you to file IA number 10?
My lord, since a report was to be obtained, my lord, till then I had no access to the child. I filed a memo.
Why you were not exercising that right in the?
He was not allowing, my lord. My lord, thereafter, my lord, I filed IA number 10. IA number 10, I filed to exercise my rights in pursuance of the order on IA number 5. My lord, that order, the court held, my lord, that you have to seek for extension of the order passed on IA number 5, and you cannot seek for implementation of that order. That is challenged in WP 21191 of
Have an order. Have an order in.
ultimately, my lord. Then I sought for extension of the order on IA number 5. That is the latest order.
Let's see. Page number.
Which order?
Page number, latest order.
Present order. Annexure A, my lord. Page 37, man. IA number 12. May I read, my lord? Permits me.
Yes. Yes, please do.
The learned counsel for the petitioner applicant has filed IA number 12 under section 12 of the Guardians and Wards Act, section 7G of the Family Courts Act, seeking to extend and implement the clause 2 and 3 of order dated 7/2/22, passed in IA number 5 regarding exercising the visitation rights of his minor child, Arabanti Datta, and grant such other and further reliefs. In support of the application, the petitioner has sworn to an affidavit stating that respondent is his wife in this case, and he is the father of Arabanti Datta and the natural guardian of the child. He has filed a custody case, and by an order dated 7/2/22, IA number 5 was allowed, permitting him visitation right, and clause number 2 and 3 of order was kept in abeyance. Thereafter, Dr. So-and-so was appointed as a counsel of the child, and the doctor has filed the report. The court at page page 15 of the order on IA number 10 has stated that he is entitled to seek for extension of the order on IA number 5 dated so-and-so. Accordingly, he is filing the application. He cannot be deprived of the visitation rights. There is evidence, evidencing and bonding between him and the child through the photographs produced by him. For all this is to allow the application in the interest of justice. The opponent respondent has filed counter to IA number 12, and she submits that the application filed by the petitioner is false, frivolous, vexatious, and not maintainable either at law and on points of facts of the case. The respondent submits that the application has been filed with an intention to harass the respondent, and the application lacks bona fides, and the same is liable to be dismissed in limine. The petitioner has suppressed the material facts and has approached the Honorable Court with unclean hands, and he has misled this court to obtain the ex parte interim order. The way of the prayer sought in the petition is not acceptable and opposed to law. On this ground, also the above application is liable to be dismissed. The relief prayed in the application is the same relief that has been made in the main petition, and hence cannot be granted. This court rightly mentioned about the trial to begin in the main case, and as per the initial cross-examination, it is clear that the respondent has failed to submit any valid proof of many allegations made against her, and one such major claim
Yes, I've seen.
yes.
Hmm.
Then, my lord,
What do you submit on this?
yes,
What are your submissions on this?
my lord, I am the father of the child. I am entitled to have the visitation, right?
Date of birth, when
Yes,
the child has born.
2017, the date of birth.
Disputes
Pardon?
between the parties.
Yes. That is somewhere in the year 2020 onwards. Throughout the marriage was there was no harmony between the
The
parties.
child was with the father till she's 3 years old.
Yes. She was born in the USA. She is a natural citizen of USA, and she holds the passport of US also.
Then the JNWC is filed in 2021.
Yes.
Hmm.
And the divorce petition is also pending.
From after 2020, when did you meet the child?
My lord, after she has gone, my lord, I have not met the child at all.
No, at least by the order of the court, did you meet?
No,
now?
they have not cooperated with the.
But till now, you have never met
No,
the child.
no.
But before that, psychologist, we were.
That is, my lord. Then I was. That is the. Then sometimes she used to bring the the child to the court. Then I have seen, but not interacted with the child freely, my lord.
Interaction never done.
No, no.
Hmm. We'll ask him.
Yes.
also. Yes, what is it?
No. EM5 order was passed, and so far as visitation in custody was kept in abeyance. Thereafter, my lords, and the pediatric psychologist supposed to be appointed, but there was no pediatric psychologist available. Then, my lords, a professor has been appointed, and my lords, she evaluates, she files a report, treating that as an interim report, my lords. When she files a memo saying that, my lords, the visitation right under IA may be permitted to exercise. Considering that, my lords, there is some delay, my lords, in furnishing the final report. Now, treating that as an interim relief, my lords, the court has, my lords, have ordered permitted him for 3 months, my lords, for, my lord, visitation rights. Thereafter, my lords, he comes up with, my lords, IA number 10, saying that he want a custodial. Court said, my lords, it is already decided that the custodial right and it is an IFI kept in abeyance and the report is called for. Therefore, you should have sought for extension of time. Then, my lords, he challenges that before this honorable court. Pending that, my lords, he also makes an application under 12 for seeking an extension of that. Instead of 3 months, he sought for extension of visitation rights under IA 3.
Well,
IA, my lords, IA 12, my lords. Then, my lords, trial court, my lords, passes an order confirming that visitation right continuation. Now, my lords, we, my lords, taking a child on Saturday there, my lords, as my lords are directed by the court. Now, difficulty, my lords, child don't want to see the face of the father, my lord, the child don't go. I am cooperating as a mother, my lords, and every date of visitation, my lord, I'm taking the child. As and when.
According to your client, what is the according to your client, what is the reason for that?
My lords, my client's instruction to me is, my lords, a domestic violence which has taken place on child, my lord. A child is afraid and scared to go to, my lord, see the face of the child, father also. That is from beginning, my lords. We got separated in 2018, my lord. I came from, my lords, 2018 and leaving, my lord, there's no access to the child.
2018,
18, my lord.
1 year old. The girl is 1 year old as on the date you left the husband. So
Yes.
what has happened in that 1 year, that girl is remembering and she doesn't want to look at the father.
My lords, that is why, my lords, having examined the conduct of the child, my lords, the pediatric psychologist has been appointed.
The psychologist, that report of the psychologist shows that there is something that your client is doing.
No, my lords, that is not.
Why
That is why, my lords, I sought, my
Why
lords,
she has
and
not attended
psychiatrist.
for the next 2 sessions?
She has been, my lord.
No, it is there. It is stated in the report that she didn't.
Now,
she
whenever
didn't appear.
child was not well, my lords, we have informed them that the child is not well, my lord. Otherwise, my lord, child, my lords, attended 3 sessions. Therefore, that interim relief, the
Then
interim report has been
can't
filed.
there be an inference that the manner in which she has been bringing her up is something not right?
No, not really, my lords. Why, my lords? On every Saturday, my lords, as per the direction of visitation rights by the honorable court, my lords, I have taken to the family court, my lord. The court also witnessed.
If you look at that psychologist report also, what he says,
My lords,
even if the daughter wants to turn her head also, the mother is not permitting, and she is going there and she's trying to hold her.
child is coming back to the mother, my lords. No,
Please come to the report. Page 150, 180. Where is the report? 153 or 83?
155, my lords.
Please come to that. You will find it. Last paragraph, 4 lines from the bottom.
Please, my lords.
The child became relaxed and was at ease.
His father was trying to communicate to the child on encouraging her to go, which made the mother very uncomfortable and disturbed. The object of the session was explanation to both the parent. It was observed that mother shifted her place near to the child and held to the child and saw to it that she could not see her father. However, the child was at age and engrossed in her drawing.
What is according to you? What is
My lords,
this?
my lords, there is, my lords, in the material place before the court regarding this, my lords. Before, my lords, a child goes to counseling, my lords. Before, my lords, after appointment, he went to that clinic, my lords, and met the doctor, my lord. That videograph is also placed before the court.
So according to you, even that now, because
No, that has been placed, my lord. Therefore, my lord,
the poor doctor has come in between to help your daughter, so both of you will again indulge them also in litigation.
my lord, he went to that clinic beforehand, my lords, and meets a doctor, my lords. This is where, my lord. And final reports are
How
not
did
yet
your
received.
client know why is she? How she could spy on this?
My lord, she has taken from the records of the hospital.
No. Why all that exercise? Generally, why
My
would
lord,
anybody
later, my
look
lord,
at it?
later when, my lords, when doctor's conduct, my lords, and in favoring to, my lords, in father's, my lords, he taken the videos, my lords, from there.
And now who else has to do it now?
No, my lords, we had the order itself says pediatric psychologist, my lord. It is not available there. I sought request in, my lords, from demands, my lords. That request has not been considered. Pediatric psychologist has not done, my lord. Therefore, that interim report has secured and permitted him a visitation right for 3 months.
What is the purpose
And my
of
lord,
having it?
there is no challenge to that order also, my lord. And he sought extension, my lords, not seeks for my lord's custody. He had, my lord, sought for only, my lords, and visitation rights. And the final report is not yet received also.
Even now, the court at this point of time, any court will not give custody.
No,
It will
visitation
only-
rights, I have no objection, my lords. I am taking, my lords.
What visitation rights he'll exercise when mother is keeping her in her lap?
No,
and,
she's 7 years old, child.
But she was carrying her. That's what the doctor says.
Doctor said, my lord,
She was carrying her at the age of a 5-year-old girl, which is not required.
child, my lord, is scared. She don't go, my lord. That is what the even family court has noticed in the court all itself.
That's what I'm saying. Why a girl of 5 years, her maturity, her this thing is not as what is supposed to be, then what the mother is doing? It is not normal. A 5-year-old girl won't behave like that. If she is behaving, then the mother is not taking care of her overall well-being.
No,
That has to be the
So far as
inference.
the child is concerned, interacting with all others, my lords, is a norm. When she sees the father, my lord, that's why. My lords have seen the report.
The family court has observed all this. That what is this, why a 5-year girl is like this? The
No,
court
that
has
is why, my
observed.
lords, a psychiatrist has been appointed to ascertain the reasons, my lords. That is, my lords, where the very purpose, my lords, a pediatric psychologist has been appointed, and we have also considered, we have also cooperated for that, my lords. And we, in fact, sought, my lords, from demands, my lords.
When if he goes to demands before? If he goes to demands before you,
I don't know, lords, if anything.
then demands of doctors are also roped into this. It is very unfortunate. It is very unfortunate that a day will come when both the parents are at in this kind of high dispute. The doctors will also not treat them. That day would come if this is what goes on.
My lords, my
Spying
only,
on the doctors.
if child
If you
is-
do not have confidence on the doctor, you shouldn't have gone to them. So a doctor would not behave like how you want. Doctor would behave. The doctor would treat as the treatment requires.
subject to my lords, he should not have made an attempt to approaching the doctor beforehand, my lord. That is what my lords gives
That
an
is there.
impression that CDs are there before my lords in the family court.
So now,
Now, my lord,
this is not going to end here.
The report, the final report are yet to be receivable, my lord.
Well, what is the purpose of the report when you're throwing
And
so many
now,
allegations on them? So now the final report comes. If the final report is saying that mother is very good, mother has taken well, girl is very
My
girl
lords,
is
my request
perfect.
is only, my lords, as per the family court order, that let the pediatric psychiatrist examine the
What
child.
I'm saying is now the final order comes. What will happen with the final order? Final report. Now again, your client has the CDs and videos. If it is in his favor, then automatically she'll come with all that. It is not going to serve the purpose. Then on this, we'll pass orders.
Yes.
Then next